My name is Mark Doran. It's April of 2023 and election time in Alberta is fast approaching. Only a few weeks ago, the Auditor General of Alberta released a damning report clearly showing that the Alberta Energy Regulator is not remotely filling its mandate. It needs to become an election issue. Recently, Professor Emeritus Mr. Nigel Banks published a blog post, something called, I'm going to share my screen, University of Alberta Faculty of Law, a blog post. And what he wrote about was specifically certain provisions of the Oil and Gas Conservation Act, which are to be used to determine which oil companies should properly hold well licenses. And in this article is entitled, "What is the status of the Shell Purity deal and what is the Alberta Energy Regulator doing?" So he focuses on section 16 of the Oil and Gas Conservation Act, which is used to license oil wells and facilities in Alberta. But he also focuses on section 11, which he quotes right here, that says, "No person," which also means a corporation, "shall commence to drill a well or undertake any operations preparatory or incidental to the drilling of a well, or to continue any drilling operations, any producing operations, or any injecting operations, unless a license has been issued and is in full force and effect, and the person is the licensee." So he moves on to deal with what I call entitlement to hold a license, and he discusses it here, and then he also, that's this section 16 subclause 1, and then he also deals with section 16 subclause 2 here. So what I'm going to do is go right to the Oil and Conservation Act, and I'm going to take that just one step further. So here we are in the Oil and Gas Conservation Act. Professor Banks looked at this section here, and there's a similar section for facility licenses. But what's important is that there are additional requirements of a licensee here, and there's something called business identification codes, which are given to operators by the Alberta Energy Regulator, and these are set out in, these are governed by what's called Directive 067. So that deals with the eligibility of corporations to actually apply for and hold well licenses generally at the Alberta Energy Regulator. So if we take a look at these additional requirements of licensee, we'll find that a lot of the companies listed as being entitled to hold licenses at the Alberta Energy Regulator don't meet the requirements of Section 20. And so it's a very simple way to make sure that that companies in good standing, or companies that don't exist anymore legally, shouldn't be on the list of those that hold well licenses. So let's just go down and take a look. Now, the main reason I'm doing this, I'm going to discuss how this that there's implications on wells in the Armisie field in urban Edmonton, and there's freehold or private minerals there. So these provisions discussed by Professor Banks take on additional importance where the minerals are freehold, and I'm going to come to that. So first, let's look at section 16 of the Oil and Gas Conservation Act. Sorry, I've gone past it. Give me a second. So it's called entitlement for a well license. So it simply says that no person shall apply for or hold a well license unless that person is a working interest participant entitled to the right to produce the oil, gas, or crude bitumen from the well, or the right to drill or operate the well for other authorized purposes, like an injection well, as the case may be. So it's very simple. You have to have a right to the mineral. So you either have to, simplified in Alberta, this means that you either need to own that mineral, need to be a freehold mineral owner, or you need to have leased those minerals through a petroleum and natural gas lease granted to you either by the freehold mineral owner or the Crown, which owns the public minerals in Alberta. So what's really important, discussed by Professor Banks in his paper, is that there's this legislated procedure. So this is a way around. The Alberta Energy Regulator will say, whether it be surface rights or mineral rights, it'll say, well, these are contractual matters. These are civil matters, and we don't want to get involved in those civil matters. So this is, in my view, the procedure in section 16 sub 2 is a procedure to get around that. So it says, if the regulator gives notice to a licensee to prove entitlement under section 16.1 that they're entitled to access these minerals, and the licensee fails to prove that entitlement, in other words, fails to produce up a mineral agreement, etc., and it fails to do so to prove those entitlements to the satisfaction of the regulator can take action, such as canceling the license, suspending the license, etc. So let's move on down to the additional requirements set out in section 20. So section 20 essentially says what types of corporations can hold well licenses, but more importantly, in 20 sub A, it says no person shall acquire or hold a license or other approval unless the person meets the eligibility requirements we've already looked at, and those set out in the regulations or rules. And in the case of a corporation, which most of them are, is registered with an active status under the Business Corporations Act. So what I'm going to deal with here, let's move on and let's take a look at Armisie Field, because there's some really unique mineral rights there. And the original company called Armisie Oil Company, they sold those mineral rights, sold the wells that had licenses, took the proceeds, didn't want to be in the oil business anymore, wound up the company, the shareholders and the directors wound up the company, and it ceased to exist in 1964. But as we'll show, it continues to hold well licenses, contrary to section 16.1 and section 20 of the Oil and Gas Conservation Act, which we just looked at. And then we'll get into why that's such a problem. Well, we're looking at Southwest Edmonton. This is the Anthony Henday Drive Ring Road, and Armisie Field, where we're going to be talking about, is right here. And we have the Enoch Cree Indian Reserve nearby. And in fact, this area to the east and all the way down to where the river is, right to this location here, this is all used to be, this part of Edmonton here is part of the surrendered portion, the second surrendered portion of Enoch Cree Indian Reserve. And that's very important. So I'll just pause again and bring up a map of the mineral rights in the area. So what I'm looking at now, what you're looking at now on the screen, is a certain area within Armisie Number Field, where the original wells of Armisie Field, a very small oil field in Southwest Edmonton, were drilled in 1951. So the surface and the mineral rights shown here in gray and also shown in yellow were owned by two different people, but were previously owned by their mother. So the gray and the yellow were owned by one person, and when she died or she passed along her rights to her children or to her heirs, these rights became divided, and so owned by two different people. And so they were said to have been combined in October of 1950. The two owners of these mineral rights, shown here in gray and in yellow, were said to have combined their mineral rights and sold and leased them through a petroleum natural gas lease to four individuals. And those four individuals are named in the caveat and in the draft copy of the lease that I've been provided by one of the oil companies that used to own these, that used to hold these well licenses. So what occurred? So I also went and looked up Armisie Oil Company Limited is the licensee of these first six wells. that were drilled in 1951, and it became a public company. So I looked up its documents in the archives. And so there was a shareholders meeting that discusses in 1962, about 11 years after these wells were drilled, that they wanted to sell some of the wells and the mineral rights to a company which turned out to be Denison Mines and wind up the company. So what's said to have occurred is that the mineral rights in gray, owned by Dr. W.S.S. Armstrong, he owned the northwest quarter, surface and minerals. He also owned this 297 feet or 18 acres within the southwest quarter, and this is of section 4, 5225 west of the Fort Meridian. He also owned that, and he also owned a narrow strip along the northern part of the southeast quarter of section 52. So he owned these three, this quarter section plus the other two parcels, all under one land title, surface and minerals. And the minerals came with it because it's part of the Stony Plain Indian Reserve number 135 when the land was sold to their parents, and therefore she inherited the mineral rights. Now, she had previously subdivided off a residential subdivision area here for acreages, shown here, Plan 5888 CL Parcel A, and she sold the mineral rights off with that. And so now her daughter, Jessie Eileen Armstrong Watson, owned those mineral rights in yellow. So they were said to have combined, the two owners combined their, and perhaps they felt if they found oil that they would share equally, because these were, that their family members should share equally, because these were originally family owned lands. So I don't really know that part. So nevertheless, the four individuals that leased these minerals, they formed something called the Armisie Syndicate. Now, Armisie is obviously a name developed from the last name of the family, Armstrong, and the mother and the daughter's name were both Jessie. So the field was named after their parent, their mother's name, Jessie Armstrong, resulting in Armisie. Now, Jessie Armstrong's husband was the first mayor of Edmonton, Strathcona combined. There were two separate cities, and in about 1912 or so they combined, and he was the first mayor of those combined cities. And I think that the reason, I don't know this following, but I think that the reason that this 297 foot, 18 acres here and 33 feet acres here were taken out of these quarter titles for these quarters and given to her son was that they knew that the power lines would come through here from Genesee Power Plant at the time was being planned to Edmonton. So I think they realized that this would be a pipeline right away going through right through there. And those not pipelines, I'm sorry, power line right away. And those power lines go through there to this day. So what occurred is that the Armisie Syndicate leased these minerals, or said to have leased these minerals, to Armisie Oil Company, and Armisie Oil Company was formed by the four lessees of those minerals plus Dr. Armstrong as president. So he's going to be the president of the company that produces his minerals, and those minerals owned by his sister. And so they leased Professor Banks discusses spacing units. The spacing units in Alberta are 40 acres, and each one of these LSDs, for example, LSD 7 right here, is 40 acres. So they leased the minerals for LSD 7 to Armisie Oil Company. It drilled Armisie number 1 here, and that well was successful. And under the terms of the lease, that obliged them to drill in an adjacent spacing unit, which they decided to use LSD 6. So then the persons holding the mineral leased these 40 acres of LSD 6 to Armisie Oil Company, which drilled Armisie number 2. And that procedure of previously leasing 40 acres before each well was drilled continued on to Armisie number 3, and then Armisie number 4, and Armisie number 5. And all of those wells were successful oil wells. So after Armisie number 5 was drilled, the syndicate signed over the entire mineral rights, all the mineral rights in gray and in yellow, to Armisie Oil Company, presumably because it had proven itself by drilling these 6 wells. But Armisie number 6 was drilled over here in LSD 8, and it was a dog. It was never completed. It never produced. And so that's how these first 6 wells came to be drilled in Armisie field, named Armisie number 1 through Armisie number 6. So clearly, if the yellow and the gray minerals are combined, as stated in a caveat on title, registered on title to this day, and these 2 people, Dr. Armstrong and Jessie Eileen Watson, brother and sister, they're no longer alive. They're both, so their descendants presumably still get the royalties from these. Well, in fact, they do get the royalties from this mineral lease. But you know, whether it's the same mineral lease or a different one or a different arrangement, that's come up in proceedings since then. So there's more wells drilled after this. But what occurred in 1962 is that Armisie Oil Company shareholders had a shareholders meeting in May of 1962, and they decided to sell the wells that were not yet abandoned. So they had abandoned Armisie number 6 at the start when it was drilled. They later, in late 1950s or 1961 or so, abandoned Armisie number 3 and Armisie number 4. That means cutting them off and sealing them below surface. Now, Armisie number 3 is a bit of a problem because there's records that the casing was salvaged from that well, creating a potential path to surface. And why that's important is that this is in a transportation utility corridor. In fact, the Trans Mountain Pipeline passes just within a few feet of Armisie number 3 here. So the remaining wells, which were the 2 active wells at the time, Armisie number 1 and Armisie number 2, were both producing and active in 1962. And Armisie number 5, well, it had been shut in and suspended since 1957, but it still existed. So the mineral lease was sold, and those 3 wells and the tank battery here and related pipelines, etc., were all sold to Denison Mines, and Denison Mines became the licensee around October 1962. So I'm going to pause here because Denison Mines and others continued to drill more wells here, and some of them were additionally there was more wells than this, 2 more wells drilled into these freehold minerals that I'm discussing. So we'll go a quick look at that. So now I'm in a database map of showing the Armisie field wells and pipelines in the area. So Armisie number 1 was here at 7-4. There's other wells drilled at that surface location. After that, Armisie number 2 is there, Armisie number 3 there, Armisie number 4 there, Armisie number 5 here, and Armisie number 6 is here. So first thing I'm going to do is just zoom in a little bit and show that 2 additional wells were drilled that were directional, which have their surface location here at LSD 3-4, where the Armisie 5 well was located. So that's the Mega 4-4 well. This is the bottom hole location, and it's directional to there. So these minerals were also owned by Jessie Armstrong Watson, and the Mega 02-04 well that comes over here. These minerals are also owned by her and now owned by her descendants. So those are the 2 additional wells drilled that were oil wells. There was additional gas well drilled here. So that's was drilled into different minerals than the oil well. So the oil well was a Blairmore pool minerals, and the gas well was drilled in the Viking pool. So that's 3 more wells in addition to the 6 wells. So that's 9 wells drilled and completed into the Armstrong or the Armstrong-Watson minerals that are freehold. So let's just take a quick look at these. And the current licensees are shown. So I'm just going to go here and we might have to zoom in just to show. So give a second here. So if we look at the original well, which is Armisie number 1, it's now licensed by Mega Oil Operations, Cedar Creek Energy, and we look at this at the survey here, it's Armisie number 1 well site, and it's shown here. So that's, we have that being owned by, the license being held by Mega Energy Limited. So if we look over here, sorry, if we look at the number 2 well, we find the same thing. But I want to show something really important, that if we look at the Armisie number 2 well, there's no survey for the well site. So this is really important. The well site was only surveyed for the first well. Armisie number 2, 3, 4, 5, and 6, no survey. This is really important because when they went to sell these wells to Denison Mines in 1962, they discovered there was no surface leases, and the owners of the minerals, they re-signed the mineral lease, but the lessees, the 4 individuals, did not re-sign it. So we have a whole bunch of incomplete documents here, and what presumably happened, what looks like what happened, is that Denison Mines said to Armisie Oil Company, well, sure, we'll buy these 3 wells from you, we'll purchase the mineral lease from you, but you don't have a mineral lease and you don't have surface because, you know, presumably because the mineral owners were involved in the oil company and they were leasing minerals with others from themselves, etc. Presumably the paperwork wasn't all done properly, or it had been lost. So presumably Denison Mines asked for all this paperwork to be redone. So we see all this paperwork for minerals and for surface leases done in 1962, when the wells were actually drilled much earlier in 1951. And this paperwork was not completed. It was not done properly. There are no well site surveys attached to most of these surface lease agreements for these sites. So the oil company, and there's no pipeline right-of-way agreements either for huge areas. So these oil companies could be trespassing here, and most likely are trespassing here. They can't show that they acquired the necessary surface rights. So anyway, that's sort of a little bit off the topic, but so the point being here is that what we really have, I'm not going to go through all the licenses, but of these 9 well licenses, 3 are still owned by Armisie Oil Company, so are held by Armisie Oil Company. So we'll take a look at the 6 of the 8 of 4 Armisie number 6 well, and that license is still held by Armisie Oil Company Limited. So it says right here, licensee Armisie Oil Company Limited. So we still have that problem with over here as well. On this well here, is still held by Armisie Oil Company. The same in this one. This is the Trans Mountain Pipeline right here in danger. So we have, and then the two of the newer wells down here. So some are owned by, some of the licenses are held by Armisie Oil Company, some by Mega Energy Limited. We've got 2 held by Tidewater Midstream. So we got 3 different companies holding well licenses, where if the yellow and the gray minerals are indeed still combined together, the same company must by law hold those well licenses. So now 3 of those wells that are still held by Armisie Oil Company, those are called legacy wells. And so there's those legacy wells so those well licenses should either be transferred to the party that leases these minerals. That would either be Mega or Tidewater Midstream, we don't know. And the reason is because this is an urban area, and there's something called Directive 079 that comes into play. So I'm just going to pause and deal with that. So now we're in the Alberta Energy Regulator's website. This is where we can find Directive 079, and it's entitled Surface Development at Proximity to Abandoned Wells. Abandoned means plugged. Now, this directive came about because of some leaky wells in the town of Kalmar where the casing was removed, just like Armisie number 3 well that's in proximity to the Trans Mountain Pipeline in Armisie Field. So, I'm not going to get into the gory details of Directive 79, but there is some details about how you locate an abandoned well, and this must be done by the licensee. Or if there is no licensee, well, then you assign this well. It must be named an orphan, and the Orphan Well Association can do it. But landowners are not entitled to locate a well, to go test, to go look for leaks, and most importantly, to re-enter that well if it is leaking, like the wells were in Kalmar. If it is leaking gas, the landowner, the surface owner, is not entitled to fix it. But these wells are in an urban area, and this land can't be safely and properly developed until somebody does this work of locating these wells, looking at the well files. They've obviously been lost, and determining if there's any leaks, and if so, and it's quite likely that Armisie number 3 could be leaking, because when you pull the casing from the wells like Texaco did in the Kalmar area, all those wells leaked gas, and these are from the same era. So when salvaging casing was done for financial reasons, when it's not good for public safety reasons. So because of this, I applied to the Alberta Energy Regulator about May the 1st of 2015 and said, would you please invoke the procedure in section 16.2 of the Oil and Gas Conservation Act that Professor Banks discussed. So in other words, give notice to the licensee and say, please prove entitlement. And so obviously Armisie Oil Company would not be able to respond. They don't exist. And so what happened is I filed this application with the regulator, and I didn't hear anything. Nothing happened, and months went by. And so then what happened was that the operator applied to have an enhanced recovery scheme approved in Armisie Field. So I was going to pause for a second and bring up a document or two that has to deal with that. So what I have here, the licensee of the field, I made a separate video on this topic. It's very complex. Applied around June the 14th, 2015, 4 to 6 weeks after I applied to have the Alberta Energy Regulator review these well licenses and transfer them to either to Penn West or to the Orphan Well Association so that the Directive 079 requirements could be dealt with. Penn West made an application. And these are all the documents for that application. And this application was made under Directive 065, and that's the AR directive for subsurface applications, including enhanced oil recovery. So here's a copy of that application. It's 1832419, and it was created here. So it was filed on June 17, 2015, and I applied around May the 1st, 2015, just before this, but I didn't hear anything. And so this is for an application for a scheme for the enhanced recovery of oil by gas reejection and water flood in the Blairmore pool. So that's the Blairmore pools where the oil wells of Armisie Field are completed to. So one of the requirements, so what I've done is I've switched over now to the written application of Penn West submitted by its agent or its consultant, which is this company here. That's not important. But what is important is that one of the requirements of Directive 065 is that the licensees of all abandoned wells in the area must consent to this scheme. So I mean, this doesn't really apply here in Armisie Field in this circumstance because the gas being re-injected here is a very small amount, is not likely to increase the pressure of the formation. But normally under enhanced oil recovery, you would possibly increase the pressure, which could affect any plugged and abandoned wells in the area. And therefore, you have to get the consent of all the abandoned well owners in the area. And so this is where this came up. So they send out a notice to Armisie Oil Company. Sorry, I'm just going to highlight that. They sent out a notice to Armisie Oil Company, who, as I've already explained, ceased to exist in April of 1964, wound up its operations, sold all its mineral rights, sold its wells, and Armisie Oil Company, being a small company owned by a doctor and some furniture merchants, they had Mitchell and Associates, which is an engineering firm and a contract operating firm, operate these wells. I actually had some dealings with Mitchell and Associates as a young man. They tried to hire me. And so anyway, Mitchell and Associates also no longer exist, but both of these companies still have a business access code at the AR, despite no longer being entitled under Section 20 of the Oil and Gas Conservation Act to hold a well license. And so they mailed out a notice, obviously, though, to the addresses on file at the AR. Those notices came back as undelivered, and that was deemed consent. So at this point in time, I challenged the AR and I said, well, look, you should determine the landowner's application first, because they filed their application first, and these well licenses probably ought to be held by Penn West. But so this was ignored. There was never any response from the AR on that. And many months later, the AR wrote to me and said, well, we're going to dismiss your application to transfer these well licenses, because a field inspector dealt with that back in June of 2015 and rejected that application for incompleteness. Well, that's not true. That didn't happen. I had filed 2 separate applications with the AR for relief, and the field inspector said she would deal with the well license transfer application at a later date, and that she wanted to deal with the other unrelated application. And that's what so that when the AR solicitor wrote and said, your application was dealt with for incompleteness, that's just not true. So the whole issue of who should hold these well licenses, whether it be the Shell Pierre Day matter that Professor Banks wrote about, or this Armisie Field matter, which is far more complicated, still is not resolved. So let's be very clear here that the enhanced oil recovery application that I'm showing you part of here is a very complicated matter, but unless certain requirements were met that are outlined in Directive 065, like getting the consent of all abandoned well licensees, the AR had no jurisdiction to decide it. And there was other issues, sour gas emergency response planning and other issues that weren't properly dealt with here either. But more fundamentally, one of the AR's basic jobs is to make sure that each and every well licenses in the province is held by a party that meets the requirements of Section 16 and Section 20 of the Oil and Gas Conservation Act. And there's clearly a legislated procedure so that the AR can quickly and easily deal with that. It doesn't have to be a big, long, drawn-out procedure. And the AR is simply not fulfilling its mandate. Now, if we have licenses held by the wrong parties, they could be stealing minerals. They could be producing and accessing minerals and not paying royalties to the appropriate parties, including the shareholders, the freehold mineral owners that are private or public mineral owners. So if we can't trust the AR to make these decisions and keep proper records of its most basic functions of who is properly at law should hold these well licenses, how can we trust the Alberta Energy Regulator to make more complicated decisions? So that's the point I want to make, and appreciate that Professor Banks has written on this, and I just wanted to take it a little bit further let's make Alberta Energy Regulator reform an issue in the upcoming May provincial election. It's badly needed. Human lives depend on it. Property rights depend on it. Thank you very much.